Yes.
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 Okay.
Okay. 3 and 8. Mr. Who's for the other side? Mr. A. Dasgupta. Have you spoken to the other side? Okay. Okay, right. Mr. A. Dasgupta. Mr. A. Dasgupta, then copy for the particular says that the matter may be adjourned as he has got a partner matter in another firm. We also submit that we will inform the other side with regard to the prayer for adjournment with time. What is this matter after? Tomorrow, no, no, not tomorrow. I'll do it.
I beg to mention for listing one matter.
Huh?
One motion matter.
Motion matter. Yes.
Unless this is case with the notice on 35, 2025, set aside the settlement on and directed the rationale of object of the within 15 days and to consider the case of the future for settlement. But the rationale of the on 25, 2025, the detail is to be set up and 25, 2025.
When do you want?
I want to know for listing matter.
When? Tomorrow. Didn't come out.
Income for this jobs. How to pay for this tomorrow?
You know, you go to the bed.
Lots,
You go to the ready.
lots of those.
Motion.
Pending.
Go to the registry.
I don't matter for things to the bank for.
Go to the registry. Pending matters, go to the registry, Mr. Kaur.
How much? Next week,
Go to the registry first.
last physical income ordered in this bylaw. 5/5/2025 bylaw. Where is the 5/5/2025?
Yes.
So where by executive to direct the status to complete their instructions and advise the court where steps required to be taken by the development. With regard to the removal of the embargo. Or Therefore, yesterday must not apply one data agreement and public. The convention is within the alpha data. But particular investment was created as part of content and stimulus. So stimulus regarding the fixed income on national tax.
That is the issue that will come up later on.
Oh, no,
No, if that is true or not, that we are not, nothing is clear on that.
is the we get to the position of the plan.
That is a different thing. As on today, we do not know what will happen tomorrow. Tomorrow, You see the right today, it is not under the Kaziranga National Park. Huh? It is.
No, if six edition is there already, that is implemented. That is implemented. If the forest, my brother is also here. We have to obtain whether it is actually within the edition or not.
See?
Sixth edition of the Kaziranga National Park or not. If that is the fact of it, then what is all things will be done.
This ban particularly ban temporarily that site for the development of the site. And by the after that, this is the map by the original map by the posters. This ban will be taken on that particular
Just
area.
a minute, let me ask this side. Let me clarify. Interjecting. No. How do you know it falls under this the area? Who told you that? When? When did you? When? Which date? 2024. And you have come to this court to tell us now. When were you pleaded? 2024. And now it is June 2025. What were you doing? And have you said in your affidavit? Let us see. Let me see the document. You will be there in your affidavit. Let me give me.
851. 851 by the Terraforma. Their affidavit 851 Terraforma.
Just a minute, Mr. Council. There is no page 51 in district commissioner. Yes, what is it? Who is the person who signed the affidavit? Page 117. 51. According to you, Mr. Council, not in my report. Either I follow you, either I follow your pagination or you follow my pagination. There is nothing stated here. Where is it? Where is it? Mr. King, please let him have his own instruction. You're trying to you're prompting him to say things which are not in the affidavit.
I'm not. That's why it depends.
I'm the one who's asking him. You're also interjecting in the middle. You want to sit here, you sit here, and then you ask. While I am asking, you should not interject. Yes, where is it stated here that this is under the Kaziranga National Park? Where does it say? Why you why are you saying things which are not there? Why are you trying to bluff this court? It may come from anybody. It may come from the president of some foreign country also. But please make your submissions as per the instructions received. Not where does it say in the instruction that the fishery that we're talking about comes within the Kaziranga National Park. That is why. Why did you say that it comes under the, it says here, why did you say that? Why are you trying to play around with this code? What comes under wildlife? It comes under wildlife. So you don't know anything whether it comes under Kaziranga National Park or not. Correct? Informed by whom? Huh? A government has informed you about what? Might fall. Are you going to take his parawise instruction or from your forest department? From who? Please, you see your information. You please give it by way of affidavit. Can you go beyond the parawise comments given to you? That is not the issue. I'm asking you a simple question. Can you make submissions beyond the parawise comments given to you? Then why are you making submission which is not here at all? Don't play around with the court. You see, you've got to make a name for yourself as a lawyer who can be trusted by the judge or by the court. You're a young lawyer, you can speak well. Because you see one thing, if we have this feeling that you say anything that you want to say, but you cannot be trusted, then maybe one or two pieces will help you. But in the long run, then the 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 image of a lawyer, of that particular lawyer who doesn't say what is said here, will continue to stick. You all talk about maybe a judge. That judge is strict, that judge is lenient, that judge might not know anything, that judge might know. Even we also sometimes say that that lawyer is a good lawyer. Don't Please ensure that you remain in that bracket, good lawyer. And Mr. Gogoi, please do not give him instructions which are not there at all in his parawise comment.
Okay, I am not with that. I asked you, you have to verify whether it is for under Kaziranga National Park.
Okay, as per this letter that they have submitted, it seems the police had gone. But that also they're talking about 15/6/2024.
Sir, okay for that.
Mr. Counsel, now it is 2025. 15/6/2024 is 1 year back.
Yes, as far as the correction period, yes.
Correct. And what have you said here? I do hereby want to inform you that adequate police force along with paramilitary personnel will be needed for removal of the embankment. So you need more police force. That is your stand.
Yeah, okay. I'm not saying that it's not right. That's now I indicate as because we is fall under the Kaziranga National Park. This was totally defined.
That we will decide when the issue comes. That is not the issue right now. That is not the issue.
It's too low. With the embankment is new close. As part of it, it's Kaziranga National Park. Then also it will be completely different.
Yes, you see, Mr. Counsel, those issues will come when you make that an issue. Nowhere in your affidavit have you taken that step. You see, your client have not taken that step. Now you as a counsel, you cannot take a stand which is contrary to the stand taken by your client. And what might happen, might not happen, we do not know. Right now we are only worried with what you are saying.
I we are not supposed to discriminate that person. Is there? Our intention is that we persist fall under their whole the whole process is equally defined.
It will be different. It will be different at that time, but right as on today,
That's why we need some variety.
Mr. Council, this big petition was filed in 2023. In 2023, there was no stand taken by you that this falls under the Kaziranga National Park. In 2024, you have gone with the police force to try and remove those persons. There also, you have not taken the stand that it is under the Kaziranga National Park. In your affidavit, in all of your affidavit, no stand. Suddenly, you're talking out of, you're just saying things which might be. It might be, but then there is no, as on today, there is no document with you saying that it is. It might be tomorrow. It might be part of. This might be part of Bangladesh also. How do you know? Or it might be part of Indonesia or something like that. I do not know. You see, tomorrow, let us talk about today. As on today, what is there? As on today, it is your stand that
We are not able to work with demolish.
correct.
That's fact. It is there. It is there. We must provide a affidavit of the first also. It is the protected area. Then also must be taken with the
Huh?
it is another protected area as far as affidavit provider.
If it is, unfortunately, fortunately for the petitioner, it is not the stand of the forest department that it is under protected.
It is under, it's the first department affidavit. It's under protected area, wildlife and.
Look, why did you go with the police force then? If it was a prohibited area, why did you go with the police force?
For the compliance of the honorable court so that it was done.
Compliance. And you didn't, and what, have you told the court that it is a prohibited area?
That
You're
part-
changing a stand. You are the one who has given in the fishery in the first.
How was it that police office that located, people go to law to demolish it located. A casualty of the located that particular area, parking is there. Children, women, all are.
That is a different issue. That is what I'm trying to address. Now you're trying to bring in a different angle. Yes,
And this project was managed by the government of India to NABARD and funded by NAFPC. For climate resilient project. And it's here, huge to the report. There in a lot of them. That's the throughout something our that it is good. So lot of people do now to go through the of picture. But the report of the page was I prepared. Because the forest was not neither met the party married, not the Kaziranga National Park. Both were not met by the petitioner. Late in 2024, last part married, forest was met party. Actually, forest is called the authority. The constructing authority is the government of India through Kaziranga National Park. So, immediately, then I want to approve with six petition. They also had it. When it was dated in 2016, Malat, this area came out of the Kaziranga National Park.
the forest department is a party here. The DFO is a party. He is filed affidavit also. Huh?
Last part of 2024.
Yeah.
It was filed in 2023. The bond was constructed in 2020 and 2020. Immediately after the project report came into being.
Where does the forest department affidavit say that it belongs to the Kaziranga National Park?
That's what I have said in my reply also. It is very delicate adapted.
You see, at the end of the day, we have got to rely on the forest department. They are the authority with regard to whether it lies within the national park or not.
We have simply said wildlife.
Then,
Wildlife. But it is part of national park, but national park is not part of the village prison. Actually, it is also not Kaziranga National Park as party.
huh?
Kaziranga National Park should be the number one park.
Where is the settlement given to you?
Yes. This book at the same.
I prefer retail.
And extra one mile.
1 crore 9 lakh.
Page 20, direction.
Page?
22, page 22. The personal subject that I told you, the government has said that not were being moral, damage not were Bhubaneswar, but for a former committee, that for a period of 7 years. Only we will take from that of taking over the position.
So it was handed over to you?
Yes.
Then the embankment was made.
Yes, all are within. at the-
After settlement, after handing over,
Yes,
settlement, the embankment was made.
yes.
Not prior to that.
Not prior to that. Because of this, there's a map also, kind of, not a kind of proof.
Yes, Mr. Who's for the PC? You come to page 22 of the report.
There is no boundary of the cricket.
Huh?
No boundary of the cricket. Boundary is a very big area. One LSC.
We do not know where.
Yes, I know.
You are not the authority.
I don't remember Parliament there, I don't know.
You may have gone swimming there. Who cares?
I was there. Boundary is a big area, LSC area.
But this
There is no boundary must be there. What boundary is there? They are saying every entire number to there. No, that's, they need to done that.
page 22. Have you got it?
I got it.
Yes.
It's there, but 7 years.
Yes. You have handed it over to him.
This is not a disputed paper.
Then now the embankment has been made after he has been given possession of the land. So you cannot go into the question of whether it is Kaziranga National Park or not. That is not the question here. That is not the issue. Because you handed over the fishery.
Correct. The whole area of the particular area mentioned there. I think is there.
Then
Only mentioned the field.
you see, it's only with, not even the bill, it's with regard to the embankment that has been constructed. You just have to remove it, that's all. Whether it is under Kaziranga National Park or something, let us see. When the proper document comes from the concerned authority, that yes, it is, but there is nothing to show as on date that it is under the Kaziranga National Park.
At the time of development, forest become assurance charge after completion of the work. So the water is coming, we will stop them there, and after this, when I use. I'm not, no, I people certainly. I look when the two deeds are there, and next one, at the time of the development of the field, that without the bank was closed, the embankment was done, and they have to take permission after completion of.
Where, promise you writing?
Yes,
Where?
page minus 25 minus. Page 25. The office of the forest range officer, Western Range, Katong on 28/5/2021. It is hereby informed by writing that excavation work of the Telecom, Solup, Tolpani Field and Dango Tolpani Field falling under the West Biswanath Welfare Division, Naksongkor is going on for development, and it has been informed to the President and Secretary Northwest Bhubaneswar Fishermen Cooperative Society Limited, promising to keep open the cell set and the mouth as per estimated of the fee. An affidavit also admitted that their affidavit or not.
So has the mouth kept open?
Not now, not open man. Earlier it was in open man. No, my lord. Two pillars there, all pushing, all water is going to both the field, right? And this is the, so thereby this is the bank file. This
But the opening is in two places or one place? One place. The opening is in two places or one place?
entire bill was one pilot, but their it was done for the development of this fishery mine.
I know they made the embankment for one.
For one side, for one.
So there has to be open, so that has to be opened up.
Yes, open and
Why was it sealed? For what reason? Why was the embankment made?
embankment made pilot for development of this fishery pilot. Water did not come. Water, for stopping the water, they first they are going to keep the close the.
After when the water went there,
And they
so they have got,
after completion of work, we open it. But they now are doing the different way. And my learned said appeared, the forest department is the member secretary. And forest department member secretary, they have all are admitted in that secretary. That we are committing and due to their disturbance, they did not do it. They're applicable second. And there is no locus because of that member, their committee member secretary is the forest department is the forest division of forest member secretary.
is the member secretary of what?
Okay, they are committee matter. My learned senior secretary of the other. So matter affidavit given by the forest department says due to harassing due to over minus they are regularly minus, so they are coming and copying.
How can he be a member secretary of, how can a forest department official be a member secretary of a society?
To go to this minor.
They're not being, how can a government, how can a member say, how can a government officer be a member of some fishery
ma'am.
society?
They are very much IA is there, minor. They step in. The rules was connected with IA minor, minor, page 65. So the government of Assam order of the governor of forest department, minor, see the rules are there and that rule the member secretary of the forest department.
You see, another thing, as per the last order of this court, last order of this court is that state respondents to complete the instructions and apprise the court as to the steps required to be taken by the deputy commissioner so and so and so and so with regard to removal of embankment. Now, in pursuance to this order, you have given this court a letter dated 21/5/2025, which pertains to an action taken by you on 15/6/2024. Correct? You are talking about something before the order. I have asked you, as on date, now what is the steps required to be taken? I'm not asking you what you had for breakfast 3 years back. I'm asking you what you're going to have for breakfast tomorrow or the after tomorrow. So please, this is what are you going to do? Look at the order.
For the kind of claim for 2025, the order specific of the claim for 2025.
Our letter shows a very specific for minor side. For the
Well, if then that means they have not answered you. That means they have not answered you. You have written a letter. You have done it, but they have not answered you because they have spoken about an action taken 1 year back where nothing has happened. We know that nothing has happened. That is why we are asking that what are you going to do next? Now this letter speaks of June 2024 incident where the police was not enough and they said that they need more police. You take more police and go.
Give another some value. Otherwise, as per my last order, I have communicated with the
They
order.
have communicated, but they have not done it.
They have proposed.
Right. This court, no, I have heard the counsel for the. This court, in its order dated 5/5/2027, had allowed Mr. K. Gogoi, the learned counsel for the state respondents, to obtain instructions with regard to the steps required to be taken by the Deputy Commissioner Sonitpur and Biswanath, with regard to the removal of the embankment which had been constructed in the fishery that had been settled with the petitioner by the forest department. Yes, sir. Mr. K. Gogoi has thereafter submitted a letter dated 6/5/2025 to the district commissioners Sonitpur and Biswanath district, informing them of the order dated 5/5/20. Yes, sir. Mr. K. Gogoi has submitted letter dated 29/5/2025 issued by the additional district commissioner bracket RE of Biswanath, along with the another letter dated 21/5/2025 issued by the circle officer Nathuar Revenue Circle Sofia to the additional deputy district commissioner bracket revenue Biswanath, which is to the following effect. Thank you. Start up as on 15/6/2024, whole arrangement till necessary act. Okay. Next. The letters dated 29/5/2025 and 21/5/2025 mentioned above are made a part of the report and marked as an X and Y respectively. A perusal of the letter dated 21/5/2025 issued by the circle officer from our Nadua Revenue Service clearly shows that attempt had been made by the police on 15/6/2020 to remove the embankment. However, in view of the crowd that has consisted of minors, women, and adults who had blocked the police force, the authorities could not remove the embankment. The letter dated 21/5/2025 further states that adequate police force along with paramilitary force personnel would be needed for removal of the embankment. Next part. The above letter dated 21/5/2025 clearly shows that no action has been taken by the respondents subsequent to 15/6/2025 for removal of the embankment, and that the district commissioners of Sonitpur and Biswanath have not made any step for removal of the embankment in pursuant to the order dated 5/5/2025, part 5. In that way, the matter, the when should they come? Let them come and exchange. That is the matter. The district commissioner Sonnet 4 and deputy and district commissioner Petronas. Maybe video to virtual are directed to appear virtually on. Please do. This Thursday. This Thursday, huh? 12th, at 10:30 a.m. to explain as to why, to explain as to what steps are required to be taken for removal of the embankment. In terms of the order dated 5/5/2025 to budget. This is the matter. Ten thirty. But actually, I will hear everyone. You see, the order dated 5/5 has not been complied with. Then I will hear you.
So I'll use the fact, I was one to two, three, how the police are doing, how the hunting, who's the.
I'll hear everyone. No, no. I think. Yes.
Nobody else, you know. Already a direction of.
Are you, is there any, who's the ferry for the other side? In air. Okay. Or at two, we might finish before that. Item? What remains out here? What does clause 32 say? Huh? What bidder should be given? Lowest bidder. All of you are lowest bidder. Huh? At the time of? Below one. How much difference is there? 50 paisa. I don't know. So what? So what? 50 paisa will not make a difference. What is the estimate of the contract? 9 crore. And 50 paisa will not make a difference. Okay. Purpose of tender is to, you see, actually what you should do is, you should challenge that particular clause where everyone has been allowed to submit only tender below 10%, not beyond that. You should challenge that clause. That is that is a tactic by which the government will pick and choose. That is happening. But you are not challenging that clause. What to do? That the clause is there. That is why every one of you all have given the same tender amount. Because you see, this thing is, you have to see. I think even the CPWD manner will allow the will allow justification for a normally low tariff. So you see, you see, because every contract, the item rate contract, is based upon the schedule of rate made by the government. Schedule of rate provides what? By and large, it says 10% will be contractor's cost. 90% is the cost for the various items. Now, and it's all based on hiring charges for vehicle transportation. Now, a person might be having 30 trucks, 40 dumpers. For him, he doesn't need to hire. So that is why if he can justify his rate, he can very well quote below 10%. But you are not challenging. No? Because of the 50 paisa. 50 paisa doesn't make a difference. Hmm. Even in 1 lakh, 50 paisa doesn't make difference. You cannot even buy one Tamul with it. If your entire case rests on that 50 paisa, there's no case. Fifty paisa doesn't make a difference. Actually, that is why they have put that clause. Unless we challenge that clause, I don't think. Who is appearing for the thing for PWD? Okay, you file an affidavit just today. Mr. S. Hawk submits that he'll file his affidavit in reply today. Accordingly, this matter day after tomorrow. It's okay. Huh? Okay, Tuesday. Next week. So this is effective.
Not in fact, let's say. Now, so far as the
Just a minute.
paragraph 16.
So the extension order was challenged, was put to challenge in the in 903, correct? And this order 19/5/2022 has what?
After expiry of the completion
Huh?
How big is it?
So,
So from 21, this would be how big is it?
so this is infrastructure. What remains?
The last paragraph.
Yes.
According to this, down in the project, there is a response.
Yes, so then the process has to go. So then,
Second petition.
wait, so this repetition is this infrastructure already, right? Heard Mr. S. Banik, clerk office for the petition, Mr. M. Tetia for. Three, four. Mr. P. Sharma for 1 and 2. Or what? No. They don't do. Huh? No, he's not there. You're there. For whom? 1 and 2. Okay, therefore, three. The counsel for the party submit that the impugned order dated 22/1/2021 issued by the Fishery Department extending the settlement of the fishery in question has been set aside. Right, judgment and order dated 19/5/2022 passed in WPC 1174 of 2022. And a fresh NIT is to be issued for settlement of the fishery. So fresh settlement was issued or not?
Yes, madam. I instruction number second petition. Finally, from 21 onwards, earlier, they see is still continuing.
Anyway, that's a different thing. Huh?
Now the present matter, tender, the present sum of they will be expired on 13/7/2025. Therefore, a new tender will be.
Okay, anyway, I will not go into this, right? Yeah. In view of the fact that the impugned order has already been set aside in WPC 117 for 2021, the present petition has become effective. The petition accordingly disposed. Item 10. Now item 11.
This was paid for the
No. No.
conviction that case can get the people of decision.
Let us see a prayer directing the response to cancel offer from giving effect to the order dated 11/5/2020. What is this?
The advantage value of the
Let us- This is also infrastructure. Nothing remains.
what we follow.
That was a different cause of action. That is a different cause of action. There's nothing remains. Huh? No, nothing. That's not. See, I'm not going to go beyond your prayer. Right, heard Mr. Pan, also heard Mr. M. Chetia for respondent number.
Yes.
First here was Mr. P. Sharma appears for response number 1. The petitioner has prayed for setting aside the order dated 11/5/2020. The impugned order dated 11/5/2020 issued by the Joint Secretary to the Government of Assam Fishery Department. By which the Deputy Commissioner Dimaji has been requested to allow the lessee, that is the point number 5, to continue, no, to run the Jenga Jan Group fishery as per existing rate of revenue at the rate of rupees 1,60,001 per annum. The, the fishery, the validity of the settlement of the fishery has expired on 26/4/2020. And this court, in its judgment and order dated 19/5/2020, marked in WPC 1174 of 2020, had set aside the extension of the lease of the fishery after the expiry of the validity of the lease period. Comma. This was finds that nothing remains to be adjudicated in its according the present date petition is also closed as it is closed as it. Now, here, why is this person allowed to proceed?
This part I don't think. And so now that already so there was an order of the court, not question method came.
Yes, why is this respondent number 5 being allowed to run the meeting?
Because if I'm under other two order, when he can, extension of the US mother department.
Yes,
There are some other department that in it, I was it myself, by extending myself. Yeah, there was. I did my also find myself. Yeah.
I'm listening to him.
Onward, 25. All from the first order, the standing order. On the piece of it. What a matter of.
You have to close this straight away. he cannot adopt to run.
Second,
Huh? So, so, yeah, where is the cancellation order? Where are you reading? Yes, yes, yes.
In view of the above,
Okay.
government after immediate action for termination of extension of fishery is as per government stating that the extension period is already over. Order separate order is in.
Not only over, it has been set aside.
No, 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 order separate order is in. To take over physical position. The fishery on the response immediately, let's take action to regulation 6.9 issue. NIT as per latest government instruction present in the issue following all the tender documents from the certificate of the data. 30 days of notice. We have already attached order to DPO also. Yes, for so only yesterday this order is in passed. Lordship, actually, Lordship, as per, Lordship asked me to agree for things. So I got the instruction. It's a call, Lordship.
Okay, in the beginning, you're right, huh? No one appears for the respondent number 5. Huh? No, no, only this, only. This. No one appears for the respondent. No notice was issued also. No?
25 and 4 of the law.
Huh?
23.5. 25. That is 4419 of 2020.
Yes, no
No, sir,
notice was
902.
issued. Huh?
903 of 21. I told you that 25 of 25. Thousand of the public debt. So, yeah.
So what we can do is we can dispose of both the writ petitions at one order. That's a mistake. Correct.
I don't know.
That's right. No one appears for the reply number 5. Huh? Next time. Then you come at the bottom. Up to the bottom, we just say the judgment and order dated 19/5/22 in passed in WPC 1174 of 2021. Wherein the respondent number 5 was also a party, has clearly stated in para 16 and 19 as per. Huh?
We have also ordered.
Okay,
In
next.
line- yes,
Okay,
yes,
okay,
yes,
next.
yes, yes. We have also ordered.
Okay, that's right. Mr. P. Sharma, next sir, has also submitted a letter as letter ECF number E-274672/56 dated 2/6/2025 issued by the Commissioner Secretary to the Government of the Fishery Department, which is to the effect that the government is contemplating immediate action for termination of the extension order of the fishery dated 22/01/2021. As the extension period is already over. Further, separate order is being issued to the DC Demaji to take over physical possession of the frigate and take action for regular settlement within a fixed timeline with issue of an NIT within 30 days from the date of this.
No, that 30 days actually
Okay.
Okay, don't do that. Don't do that. Cut that with it. Good stuff. Next. On concentric. No, let's start. Mr. M. Chetty has submitted a letter dated 31/5/2025 issued by the District Fishery Development Officer, Dhemaji, to the Additional District Commissioner, Bracket Fisheries, that was Dhemaji, which shows that the respondent number 5 is running the fishery. Is to run the fishery. Is to run the fishery till 13/7/22. This time. On perusing the judgment and order passed in WPC 1174 of 2020. There was no ground for allowing the respondent number 5 to run the fishery beyond the date of the judgment and order passed in WPC 1174 of 2021, that is 19/5/2020. In that view of the matter, the respondents are directed to immediately take over possession of the fishery question of the Tengajan Kribijan fishery. This, no. Yeah, Tengajan group fishery, from the respondent number 5. And take steps for settlement of the case to accuse the offender. That's all. No, add on this. First off, it is made clear that if the respondents do not take immediate,
He is not an authorized, he is AFPO.
it is made clear that if the respondents do not take immediate possession of the fishery from the respondent number 5, contempt action may follow. The action for non-compliance of this order will follow. Compliance of this order and the judgment and order passed in WPC 117/2021 may follow. Again, the hearing official and the respondent number.
Okay. The officer will sign it.
The writ petitions accordingly disposed.
Right, okay, right. I love like that. I have to get there on that.
Who?
It's like it in I have to get there.
So where is he?
But I just say one thing about that.
Yes.
There are few things. Another is 11, 12, 2014. Why I say 11, 12, 2014. I should have placed 11, 12, then 12. Or 12, 12, 2014, then 11, 12, 2014, 21st of January 2015. Either only
2015.
50. Either two. And we are telling you notification order to governor of 166 by notification of 12, 12, 2015. Whether the notification issued by the Labor Department. We are the Indian senior citizen, representing for the employers. Employees also might have employees there some because they use the notification issued by the employees and they say by the Labor Department. And they are saying, my lord, there are 3 sections in the department. Kindly note down. One is section 3 of the Minimum Wage Act. One is section 5 of the minimum wages regulator. And one is Rule 23 of the Assam of minimum wages rule 1950,
Rule 23
Rule 23 4
of the,
minimum Assam minimum wages rules 1952. These are the what our article is that notification before December 12th of December 2004 and the sections which were said all these procedures are not. What are the procedures not?
what is the notification?
I look into notification. That pays for
40.
totally.
Yes,
On 12th of December 2014, kindly see on the top order by the governor.
yes,
Notification. In excess of our controlled by clause A of subsection 1 of section 3, where the section subsection 4 section 5 of minimum wages act 1948 and provided under rule 23 4 of the Assam minimum wages Act 1952, governor will assign to notify ordinary unskilled employees, duty rated employees in the tea plantation of the state payable for the rest pay in the 30 days or 7 days in addition to the working days to which an employee is entitled under the provision of the census to be covered. Please see the notification before reading. I just quickly I will show equal lordship turn to page 41.
just a minute, just a minute.
Yes.
Please to notify. That the end, okay, so he's entitled to pay for the rest day.
Yes, we are paying it. Well, our whole stand is that we are not buying it. We are paying it 23 for those 23 4. How it has been fixed under the rules of that also has been followed and it is spelled out in our categorical. We have not violated the rules. But here by the every there is a revision of wages. So now if you see the minimum wages, kindly look into the minimum wages act, because that's what they have said. Section 3 first.
Yes, section 3.
Section 3, because they have said section 3, if you not take look to page 40, probably of subsection 1 of section 3, right? Now, minimum fixation of minimum rate of wages, approved as government standing.
No, we can.
Section 3.
Section 3 is what the appropriate government shall.
Shall in the manner wherein after provided. 1A, fix the minimum rate of wages payable to the employed in an employment specified in part 1 of part 2 of the schedule and in an employment scheduled to either party by notification under section 27. Now, if for a moment, I don't know which is the book your lordship is carrying. If your lordship looks into the schedule part 1, here it is reflected to 35. Schedule part 1.
Yes,
T 4.
yes,
This is employment in any planting. That is to say, any state which is mentioned, so this is what they are mentioned. Employment is in planting. Okay, got it?
yes,
Now we go back again to section 3. Kindly listen to section 3 now.
Yeah.
Okay. Provided with the appropriate form and with respect of employed situation, so instead of fixing minimum rate of wages under this clause of the whole state,
no, where are you reading? Okay, provided, yes.
provided that the appropriate government made in respect to the employed in any employment specified in part 2 of the schedule, instead of fixing minimum rate of wages under this clause for the whole state, fix a rate for a part of the state or for any specified class of process of such employment in the whole state or part thereof. This is not so much important, proviso, because if you see now, if you see the section 5, this is section 5. This is fixing of minimum wage of wages. Now, if you see the procedure is at section 5. See section 5 procedure.
Yes.
Procedure for fixing and revising minimum wages. In
Yes.
fixing minimum rate of wages with respect of any scheduled employment for the first time under this act, on in revising minimum rate of wages so fixed, appropriate government shall either A, appoint as many subcommittees and subcommittees as it may consider necessary for inquiry and advise with respect of such fixation or revision as the case will be, or B, by notification in the official gazette publish the proposal for the information of person likely to be affected thereby and specify a date not less than 2 months from the date of the notification on which the proposal will be taken into consideration. So there are two things for each year. One is they may appoint some committee or subcommittee, what we call it, and they will hold an inquiry and advise and they will say what is it, how it has to be paid. Another mode is by notification. In the official gazette, they will publish my law.
Proposal.
They will inform the stakeholder, maybe ask the stakeholder whether you have got some objection or not. That's the procedure. Now, if you see 5.2, after considering, now this is important.
Yes.
After considering the advice of the committee or committees appointed under clause A of subsection 1, or as the case may be, all representation received by before the date specified in the notification of the clause B of that subsection, appropriate government shall by notification in the official gazette fix, or as the case may be, revise the minimum rate of wages in respect of each scheduled employment, and unless such notification otherwise provides, it shall come into force on the expiry of 3 months from the date of its issue, provided that when the appropriate government proposes to revise the minimum rate of wages by the note specified in clause B of subsection 1, appropriate government shall consult the advisory board. Now, our case, my lord, this procedure is not important. 1, A 518 says committee or a subcommittee. They have not done. No report has been done. B, or they can resort to a publication, which they have not done. So if they have not followed the procedure, the first point which you are taking, 12/12/2014, argument, for an argument's sake, let us say,
Just a minute.
Yes.
In exercise of the powers conferred by clause A of subsection 1. No, but this is not with regard to the quantum of pay to be
the
made.
quantum is different. The quantum is minimum,
This is only for minimum wages,
I know, but then the procedure is fixed
correct?
before.
But it depends, you see the quantum, this procedure is with regard to the amount that is to be paid. It is not with regard to any other thing.
Amount is 23 under the rule. In what manner it has to be split, it has to be prescribed.
Just let me see.
But before that, the logic looks into 5. Because they have passed the notification.
No. You see, this 5
Yes.
is for fixing and receiving and revising minimum wages. So it is the quantum, it is the no procedure is there. Prior to fixing the minimum wages, the procedure is there by which committees or subcommittees can be formed, number one, or the proposals have to be notified in the official gazette for which representations can be made. So on only by following these procedures, either of them,
Yes.
can the minimum wages be fixed.
Right.
So now, what I'm trying to say is, this page 40 of yours,
Yes.
this notification of 12 Feb, this has not fixed the minimum wages. This page 40 does not fix any minimum wage.
That I'm not that.
Okay.
But I'm on that this 23 4 stipulates in what manner the quantum is being taken. There is
What?
no problem.
He wants to tell you something.
Is what I'm understanding is saying. These notifications for revising the minimum. Time to time it will be revised.
Correct.
This is only.
So for revision also, I think the same
Yes.
clause, section 5 will have to be followed.
Same procedure.
Yes. So that's all
Same
right.
procedure.
So why are you challenging this?
No, teacher, we have to challenge one. Final time is it is one. Why? When you are fixing a particular revising a rate,
Ah,
first you have to notify. Number one, you have to-
either you notify or make a subcommittee.
they have not done. One. Whenever it is just for particular.
No, but where have they quantified?
In addition, in every rest day, in every period of 7 days, in addition to the working day, to which an employee is entitled on the provision of this Plantation Labor Act. Where is the question of in addition to working day, again is entitled on provision of Plantation of Labor Act 1951. If we month, this is 23 4, now that should be clear.
For the rest day, in every period of time.
See 23 4 minus 3 to clear.
Okay.
What is 23 4? 23 4 under the minimum wages rule 1952.
Yes,
An employee, what's about it? 23 4.
yes.
An employee shall be granted for the range of wages calculated at the date applicable to the next preceding date. And in case he works on the race day and has been given a substituted race day, he shall be paid wages for the race day on which he worked. And an overtime rate and wages for the substituted race day at the rate applicable to the next preceding. Provided, now time will be provided.
An employee shall be granted for the rest day wages calculated for the rate applicable to the next preceding day. And in case he works on the rest day, he has to do substituted rest day, he substitute wages for the rest day.
Now next day,
The overtime rate and wages for the substitute.
now next day, preceding day is given as a provided that where a minimum daily rate of wages of the employee as notified under the act will be worked out by dividing the minimum monthly rate of wages by 26, or where the actual daily rate of wages of the employee has been worked out by dividing the monthly rate of wages by 26. Daily rate of wages is not less than the notified minimum daily rate of wages of the employee. No wages for the rest day shall be payable, and in case the employee works on the rest day and has been given a substituted rest day, he shall be paid only for the rest day on which he worked an amount equal to the wages payable to him at the overtime rate. What's the 45?
Not really.
I didn't explain. But my lord, I am just giving an example. So you get 10 days market. So in 7 days, per month will be 300 rupees.
If
10
I get,
days, we'll put an example. 10 days for unskilled labor. 10 days is being paid, that is wages. 10 rupees, 10 rupees is paid. But 30 days it is 300.
Correct.
Correct. Now if it is 300, then your lordship I'll put calculation. I'll just give a calculation which makes it easier. Now, per day, it will not be 10 rupees because they get overtime because of the rest day. Rest day has been calculated also. So they will get 300 divided by 26, which is as per the act. 26 will be 11.5. I calculated, I told you we
so
calculated
they get say 10 rupees per day.
per day,
So for a month, it will be 10 into 30, 300.
300.
Ah,
Now 300 divided into 26 days, there are 26 days.
why 26?
Yes, they. Because they are getting paid for the rest day also.
Correct.
So that is what, how,
So 26 days is minus the rest day.
that is what, how it will be calculated. Can you see this?
26 days will have to be minus the rest day.
No, no.
In a month, usually they are 4 weeks.
Here,
In a month, usually they are 4 weeks.
right.
So for 6 days, they will work in a week.
Yes.
The 7th day will be a holiday. Holiday. They will get wages for the 7th day also.
Yes, correct.
Then
And 7 days have been calculated. Can you see this, and how it has been calculated? The calculation scenario, provided that where the minimum daily rate of wages of the employee as notified under the act has been worked out by dividing the minimum monthly rate of wages by 26, or where the actual daily rate of wages of the employee has been worked out by dividing the monthly rate of wages by 26 daily rate of wages. What is
has been worked out by dividing the monthly rate of wages by 26.
now dividing by so and so notified minimum daily rate of wages, no wages for rest day shall be payable, and in case of the employee works on the rest day and has been given a subsequent rest day, he shall be paid only for the rest day on which he worked, an amount equal to the wage payable to him at the overtime. So your lordship is right. Your lordship is correct. Then suppose I work for 7 days, 7 days I will get it. 7 days I will get it. Because rest day also, Monday, Tuesday, Wednesday, Thursday. Monday, Tuesday, Wednesday, Thursday, Friday, Saturday. Sunday, even rest day also it has to be calculated. Am I correct? Manoj? That's what it says. That's what, no, no, that is what I say.
So if a person is
But
getting,
notification says in addition to that you have to pay. That's what we are agreeing. See the notification.
let us be very clear of this.
Yes.
The rule 23.
Yes.
They provide. Provided that where the minimum rate of wages of the employee as notified under the act has been worked out by dividing the minimum monthly rate of wages by 26. Or where the actual daily rate of wages of the employee has been worked out by dividing the monthly rate of wages by 26, and such actual daily rate of wages is not less than the notified minimum daily rate of wages and before the employee. No wages for the rest day shall be paid. So, and in case the employee works on the rest day and has been given a substitute rest day, he shall be paid only for the rest day of which he has an amount equal to the wages payable to him at the overtime. And if it is so, with regard to any dispute, he has to go to the labor commissioner.
Yes. Well, there is no question in this system. What we are dividing challenge notification.
They cannot see a notification.
Why? Because they have not followed the procedure in section number 5. That is one. Secondly, we are paying as per 24. You cannot ask us to pay something which is addition to the.
No, what it says here, it appears that it is, where the daily rate of the wages by 26%, actual daily rate of wages of the no wages for the rest day shall be payable. And in case the employee works on the rest day and has been given a substitute rest day, he shall be paid only for the rest day on which he works an amount equal to the wages payable to him at the overtime. So basically, what does it mean? Supposing in a week, Sunday was supposed to be off day, rest day. But he has worked on that. Then he'll be given wages for that, whether he takes a holiday or not. But if he works, he should be given as the overtime. That's not
Yes, yes. But that we are not denying that we are not paid. Why we are challenging notification? Because time to time the decision is being made by the government. As per the section 3 and 50 has been taken. So they said what we are agreed. They said whatever you pay, in addition to that, kindly see, in addition to the working day to the employee, is entitled on the provision of Plantation Labor Act 1951. Where are you reading? And the page 40 of the notification. But they know that is not a mistake. Thereafter, it pays 45 contributions.
No, plantation, plantation labor act. What is this plantation?
Plantation Labor Act kindly look into it. Ma'am. All 45. Huh? 1960, 46, 845. 845. That's why I want to say 845.
Yes,
See the corridor. 21st January 2015. This is to notify the work of the fifth line of the notification dated 12/12/2014 between the under plantation of the state and for the waste state in case of favor, may be entitled for working. And in the seventh line, place of plantation before 1951 may be rated there.
so it will be the minimum wages act.
They are not saying whether minimum wage, they say different. No, my not, we are complying with those particular, the provision under 23(4). This is what we are challenging. One is that.
No, but where is the revision of the pay? Where is the upward revision of the pay being made?
No, what is the procedure they have adopted? How
No,
they
no,
have
no.
followed?
Forget the procedure. Where is the document showing that the pay has been revised from 10 rupees to 15 rupees?
That is what we challenge.
No, but it is not that, then how can you challenge it?
No, that's what we are saying. That their subcommittee has to be there, report has to be there.
No, that is all right. That is all right.
The main point.
No, I understand. What I'm trying to say is, right now, according to you, you are paying the minimum wages.
Yes.
Now, the minimum wages according to you is rupees 10.
Yes.
Now, as per these documents that they have put to challenge, that rupees 10 has apparently been raised
Yes.
to 15 rupees. Now, where is that 15
That
rupees?
is what I'm saying. That one. Government has to do it, not us.
Correct.
Government.
So why you bother? They have not done it.
No, that is why we have come up and challenged this notification.
No.
You have fixed it.
They have not fixed. There's nothing.
That is what in addition to working days. You see, trying to see at least 40. Okay. Yeah. Why not? What are the time 50 years, 50 years?
Is entitled under the entitled under the provisions of the act. It says that plantation act is there.
In addition to working days, this is what we are agreed upon.
In addition to working days.
An employee provision of plantation labor act 1951.
No, but then that you said that has been deleted.
No, they might not be kindly see now. If it is also being deleted here, where is the position of the notification being issued? And they are saying,
So this notification is of no consequence.
then who consequence is original which has to issue sign. In first place the notification. In first place notification of 12th of December 2014.
Correct.
Where is the picture? You have to buy.
So there's no revision. So don't pay.
No revision,
So
then-
there's no revision. Don't pay. They have not brought up.
Then notification will not pay. If that is the case, we are paying it.
We
How
challenge-
can you pay under under what, how can you pay?
No, the challenge because the position
No,
of
you
the-
show me, you show me that earlier you were paying this much minimum wage.
Yeah.
Now, because of this notification, the minimum wage has been raised to this much. Show me that. There's nothing.
So, not the- what I'm saying, whenever-
Correct, that has to be
So
followed.
they may come up and they say that they may do it. And notification is the procedure is the same.
Let them issue, so what? How does it prejudice you?
Not important, what the next page 41.
This matter.
Page 41.
Yes,
In the 11th of December 2014,
yes.
in exercise of our concordance of section 12, so the plantation of a state paid rest day, in addition to working days, is entitled to political effective labor at tax 51. Kindly see the date, 11th of December 2014. Kindly see the date. Look at the gather petition. Page 41. And see the page 40, the notification.
No, no, no. You see, this 11 December 2014 has been superseded by the 12 December 2014 notification. This 11 December notification has been superseded by the 12 December notification.
They have not taken.
This here, page 40,
Page 40.
yes, now, this supersedes earlier notification event. At the last time, as separately it is done.
It's supposed, it,
Earlier notification, if any.
are they? No, forget that notification.
No,
No, these superset earlier notification for gazette notification or order passed by governor. This has to be notified. This also has to notify gazette notification has to be there. This 12th of December 2014 has to be gazette notification.
anyway, let them clarify, but right now I don't see any prejudice being caused. to you.
No, it is for now you see, my lord, section 5 is any notification issued has to be gazette.
No, that is why, since it is not gazetted, since 12 is not gazetted, according to you, how does it appear?
But they have continue better saying that please subscribe to the notification. No, notification. Oh, we have annexed that, kindly look into it. Kindly look into it. 42 is the type of it, kindly look into it, 342. 342.
No, rest days wages, so you have to give. There is no doubt about it.
No, we have been paying, we are not saying, you know.
Then where is the problem?
See, no, there is a problem because of this letter, kindly see. You are therefore
You,
requesting.
you write to them back and you say that we have been paying, that's all. What is it?
So, why not always? That because so easy, why not you not come to the court, they trouble this court. You don't have come and trouble the court.
I don't know, because you see, there is, what is the minimum wage that you are paying your workers?
250.
You are paying them 250?
Yes.
Now, there is no notification by the government saying that minimum wage should be 275 or 300. Correct? There's none. As on date, there is none.
But you see this.
No, forget that. Figures, notification with regard to figures, there is nothing. So where is the violation of any of the provisions of the act? How does it prejudice you? I don't know. They have not told.
See, but
Uh,
you see the epidemic that here goes up. In their epidemic paragraph 12, paragraph 12 of the epidemic. Their epidemic says,
Paragraph 12 of
12 of the epidemic resolution filed by the state on the 6th of February. Paragraph 12.
yes.
that with regard to this statement, making para 10 of the repetition, deponent while denying the contention making basis of it, notification published in the present 40, 12, 40, 14, wrongly quoted the date of issue notification on 11, 12, 14. Notwithstanding, the errors kept up in the notification dated 12, 14, and in subsequent content, payment of wages for the grace day certificate of 7 days is territory under 13 1 of minimum wages Act 1948, 24 of the money minimum wages rule 1952. In fact, no notification on LC under the Act. Now they are saying, in fact, no notification on LC under the Act for payment of wages for 50 days for rest as is stated. So if you are saying no notification on LC, then why are these notification?
No, how does it matter? This is because you have to give them 6 days of working plus 1 day of rest day you have to give. So in effect, they're giving them 7 days of,
250, whatever it is to 50 I have to pay. But why this notification? How? What you are stating in the application? It is not the helping of my notification. Why am I saying notification? In fact, no notification was there. Under
Correct,
the Act.
correct, because it is provided in the act itself.
Right. So this is why. And when you want something to be increased, why? This come up with some committee, subcommittee, or.
There is nothing, there's no increase.
But now, since only find out why we have been reacting this to giving a letter to us comply. What notification?
Giving work to lawyers, that's all.
And what we are alleging, minor trying to see, therefore, it is evident from the foregoing paragraph that tea garden management have failed to pay wages for the day of rest to their employees in the implementation of it.
So basically, they are saying that you have given only 6 days of wages. You should give 7 days of wages.
What,
So that is what, actually, that is what they say. But you have been paying for 7 days.
we are paying as per the provision that has to go down under 24.
So you have been paying for 7 days.
And which has been calculated under the rule. So that's the whole case. That's the whole case. And it may also be paid as per that specific amount we are paid in the affidavit CPF file.
I don't find anything. Yes, he's busy. Because there is nothing, there is no raising of the minimum wage, there's nothing. They are saying that they are paying for 7 days.
And what they themselves agree that if it is for a statute which has been laid down, there is no pressure. And if you are revising it, suppose you are revising.
If anything is that section 5 will take place.
Then otherwise what would happen? As if find out if you are under 3, 5, under 5 also, there some revision is there. Some report may be there. Some report may be there. We don't know. What is the revision you have made it? What is that? They are
Are your employees, are they being employed weekly or monthly?
daily rate.
Daily.
Daily asking daily rate. Asking daily rate. Well, my equally favor and yes, their whole case is that what I appears, last 2 lines we say, rest day we are not paying.
That's what it appears.
But we have.
But we have said that we are paying
We
rent.
are paying. We are paying. And what was the use? Themselves they taken. No. Notification was not there. Then why you are thinking? That as if a notification has been issued on the ground that there is some revision of pay, some revision of minimum wages and other prices.
So that is not being brought out.
But they, John Hospital, there is notification. Notification has been read. When I read the notification, I will definitely go into section 3 and 5. And 24, whether 24 has been supplied by us or not, that has to be looked into it. If 24 is not concerned, then of course, they can, and if 24 is not concerned. So what was the point? They themselves said the notification should go, and your object is 24 has to be supplied. That's the case, fine.
What to do?
So this is 2015.
Yes, no. I am ready also to dispose of.
1.4 that is headache.
Correct. Only problem is I don't find anything in this case. I mean, from the government, they are writing letters to you, but that letter because your stand is that you are complying. What remains to be decided, I don't know. The only thing that appears to be the issue is that you have not been paying for the rest day, which you said you are paying. That's all. What do you mean?
As per 24 you have to. Things by the rule. As per the procedure that has been 24.
Okay, right. I had Mr. Read asked Wednesday Carpet for the petitioner. Petitioner assisted by Miss and Padya. Your father was that uh, uh, Mr. G. Bokalier appearing for the state respondent praise for adjournment. Is it?
Yeah.
On the ground that Mr. P. Nayak, learned counsel for who?
For all the respondents.
For the respondent. Acha, P. Nayak, additional lady, is on legs in another foot. Right. So which have we challenged? 11, 12 or 12, 12? Only 12, 12 and that 21, 1. What is that?
21 1.
Let us see what is better. Huh?
21 1.
Page?
Page 45.
Okay, right. The petitioner has put to challenge the legality and validity of the notification dated 12/11/2014, 12/12/2014, 11/12/2014, and 21/1/2015, issued by the Commissioner Secretary to the Government of Assam from a Labor and Employment Department. The counsel for the petitioner, the senior counsel for the petitioner, submit that in terms of Section 3 and 5 of the Minimum Wages Act 1940 and Rule 23 bracket 4 of the Assam Minimum Wages Rule unskilled daily rated employees are entitled to wages for the rest day in a week, and as such have to be paid wages for the rest day as per the day preceding the rest day. He also submits that in terms of Rules 3 and 5 of the Minimum Wages Act of 1940, hereinafter referred to as the Act, the appropriate government is to appoint as many committees and subcommittees to hold inquiry and advise the government for revision of fixation of minimum wages. In the alternative, the government is to publish the proposal by way of a notification in the official gazette for revision of minimum wages. And the public are to submit their replies to the proposal made by the government. It is only after either of the two methods are followed by the government that the minimum wages of unskilled daily rated employees can be reached. The petitioners also submit that in terms of Rule 20, Rule 23 bracket 4, 23 bracket 4 of the entire minimum wages rule, 19, hereinafter referred to as the rules. Is to be granted wages for the rescue. And as the petitioners have been giving their daily rated employee wages for the rest day, comma, the reason for issuing the notification, impugn notification, by the state authority is without any basis. It submits that the only inference that can be read from the impugn notification is that there has been a mistaken belief on the part of the state government that the petitioners have not been paid wages for the rent day to their daily, to their unskilled daily rated employees, which is actually to the contrary in reality. Next time. Section 3. Section 3. Which part? Section 3. 1. Section 3 1. Yes. Section 3 1. And section 5 of the Act are reproduced therapy. The next para is right. Rule 360 bracket 4 of the rules to reproduce therapy. This is the matter on when? Tomorrow, after when? Next week, Thursday. Why? Why? This is the matter on Thursday. After tomorrow is motion day. To be. Which is para 15.
One power.
One? There's no 51. 1 5, okay.
That's what the constitution of sort of says. That's what I read. Of the ethical operation of interest in the life, the important part that
Okay, just before section, the senior council submit that the wages paid to a unskilled daily rated employee for 26 working days is calculated taking into account the requirement for 30 days, thereby already paying to the workers wages for 4 rest days every month. That's same thing. I said weekly, you said monthly. Yeah. Then I will see, list the matter, huh? Then list the matter. Thursday. Oh, you got a huge matter, which has been going on forever. We can listen, let it be. We can make this before that. Could not.
come up with something else.
I don't know what is there to decide here. It's a question of fact. That's all. It's a question of fact.
On fact, he said we are paying. What he was saying, everybody is very fine.
What have they said in their affidavit?
They said, don't pay for the wage.
That is a disputed question. Oh,
We are paying it. No, it's not on the basis of the provision. So we are paying
okay. So how much are you paying? 200 and
250.
per day.
Now, what is there? Or are we going to take the structure? There is a provision. The wages can be given in the state of effect. Assam amendment section 5. We get it. What is the actual what we are saying?
So aren't you paying it as per the minimum wages act?
Yeah.
They're paying.
Yeah.
So 250 into 30 will be 7,500. Are you paying that much? Oh, that is the problem.
That
That is the, huh?
that is the way how it is. That is the manner of more people thinking. That is what they before. That is a calculation which is in accordance with the procedure.
What is the minimum wages given for an unskilled daily rated? Where is that? Where is the, what is the notification?
We'll go to but what we have seen, that incident also, there is an information.
Look, if you are employing person on a daily wage basis and you are giving him wages for all the days of his working, correct? So why should it be divided by 26?
That is the procedure. You see the procedure.
Some citation?
I thought so.
Can you give me some citation?
But that's the procedure because we can't go beyond the.
Huh? Yeah.
Other things to the cooking also having other things. We will adjust ourselves. We will adjust ourselves.
You see,
This is what the.
this is everywhere. Like your opponents are not here today.
So is the part of.
Done. Oh, this is, put this in there. Yes, you can start. Yes, Mr. Didas, this, uh, this is the junior can come. No, this plantation act, plantation act. Correct. Then, yeah, you know, we know. Correct. You see, I remember when I was arguing a matter, Justice Whitney was on the other side, I was on the other. It was a bail matter. And the court asked me, give me your advice. I'm arguing. What do you think? Is it bailable or not bailable? I told the court, Anand, since you have asked me personally, yes, he's got a point. It's not bail. And he allowed me. He allowed. And I noticed from that day, whatever I said, whenever I said, he used to believe that at least is the truth. I might not have one or two things, but so he believed that what I said was the truth, always. So that is a very important thing. Yes, very important. Correct. Ah, correct. Ah, correct. Yes, Supreme Court to hardly any time. They're so busy. I don't know, but in some high courts, they have got 300 cases in a court every day. Yes.
We think it does not find the timing.
Item?
I think fine.
This is right of way. Okay.
I therefore estimate about 1 to 50. 15 is above the compensation equal to 6 or 4. And then it is settled.
So there's a settlement has been arrived at with you.
Fact, but they were not vacating the lot. Right, or they are vacated. They filed title also.
Okay.
But that thing has to be withdrawn by them, so they left the what for the title.
I forgot to pay the 50 is what.
Is there left? How does it? When is the settlement?
In the injunction also. You know, that is in our IA, the file that was also disposed of. Your lordship, they have the, your lordship order dated 4/12/22.
Post self. What about the provident fund and gratuity?
But that has to be right in the fully final settlement. Okay, that has to decide it. Either they come up with like a
Where is the final settlement?
final settlement, not that is in our IA, file is IA,
2422.
242. The minute, right copy the page 65. Correct. Seven, eight.
So they have all retired or what?
They have retired long time.
They'll leave the quarters. Nothing really.
For that 3% I'm not interested.
Whatever. They are part of the settlement of
That's part of it.
so everyone has to leave. Are they those 3% here? Parties?
They are party. They are the only one entity.
Who was who?
Subsequent development project. But what settlement has been arrived from today.
28 to 2020.
And accordingly, payment has been made as my client all of this.
February 2020. The only reason not they have a file that I think
Who has that? Yeah.
no, only the respondent number 81114 they have obtained in the I was pending. So the lordship has taken a view that whether this fact was
Brought to the notice
got
of
to the
the.
notice of the trial. So that was not possible.
So why you are there also? You are before the trial court.
Yes,
And why don't you bring it to the notice of the trial court?
I'll do that. But observation may be given.
Heard Mr.
And but
Senate counsel for this petition. Also heard Ms. A. Bhattacharya for
Respondent number, Assam proposal of respondent for 50. Representing the what?
only 15.
Representing the what?
No, there's so many of them.
I
Even the second copy. You should bring your own file. The minimum that you can do.
I'm sorry, my lord, because it is settled out of game and that's why I must be given. I'm sorry for that.
You should know who you represent.
I am representing all the workers.
Not all. You said you're not representing three of them.
4 to 14.
You're not appearing for whom? 8,
I am 8, 8, 11 and 14.
8, 11, and 14, you're not appearing. You're right. Appearing for the respondents number 4 to 7, 9, 10, 12, 13. No, no. 4 to 7, appearing for 4 to 7, 9, 10, 12, 13. No one appears for respondents number 8, 11, and 14. Mr. G. Bokhalel appears for respondent number 150. The counsel for the party subject that parties have settled the matter out of court. Well, has been decided that the petitioners will be picked up you're appearing for who? The petition. It's not petition, respondents, huh? Respondents 1, 2. Okay, have settled before, have settled, have made a separate during the conciliation proceeding.
It was directed from the
Conciliation proceeding before the assistant labor commissioner people. On 22 to 22. Next up. The counsel for the petitioner submits that despite the above settlement having been made, the respondents number 8, 11, and 14 are still occupied the official quarters. Correct?
they have vacated them,
Yes?
but the title show has not been restored.
Okay. Submit that, submit that. Though all the respondents have vacated the tea garden quarters, the title suit number 80 of 2024 filed by the respondents in the court of the civil judge bracket senior division, has not been withdrawn by the respondent. Next up, Ms. A. Bhattacharya, present counsel for the private respondent, submits that agrees with the submission made by the petitioner's counsel that settlement has been arrived at between the parties on 22 to 26, and that nothing remains to be adjudicated in this respect. However, the question of withdrawal of the title suit number 80 of 2024 from the court of the senior civil judge would have to be done by the private respondent, especially respondents number 8, 11, and 14, who he does not represent. Next one. This court, in its order dated 4/12/2024, passed in WPC 56 of 2016, and recorded the fact of A settlement having been arrived at between the parties. And the consequential result of the settlement that led to the payment of provident fund and gratuity to the private response. Correct? Okay. Next term. The settlement of the settlement made between the parties of 22 to 2020 before the paper for the produced here in the page 65 67. Yes. Yes, sir. For the request of the IA, of the IA. 2422. Next. In view of the settlement having been made between the parties, and as the private respondents have all left the official quarters of the petitioners should inform the concerned court of the civil judge senior division principal in title suit number 80 of Spencer with the fact that the there is nothing to be adjudicated any further in title suit number 10. The writ petitions accordingly disposed. After you see title suit, wherever I have said title suit number, so you also mention title suit number 80 of 2024 and Miss bracket J, case number 130 of 2024. Is the both of us. I also will have to. Both of us. I do. What is this matter, madam? Petitioner. In item 6, you are for the workman. So item 6 is by the petition. How you asking for the first? Huh? We can hear it now also. Who is for the other side? Who appears? Have you got any paper?
Award of mistake 60% graduation. And that's not but
There is no requirement of this. Whenever you terminate it, huh? A button current. Option for the petition of public that he is not ready with the fact. Accordingly, this is pattern. After we'll see, madam, we'll see, we'll see. Okay, let us see now. This is the matter of. We'll see, you get ready with the fact. Then I'll see this required. Yeah. What is to be done here? Do they have any money to give to the protector? It is liability towards the protector. So. How can they be the principal protector? How? This is because you're working for the, who are the private responder? Who is the respondent number 5? This is the petitioner, correct? This is one contract work. There is a question of principal protector. That's not a principle of, so under what? If you want more, contract labor. Okay, already there. It's about 25. It's about 25. 25. Okay, right, we will adjust the matter. And if we now go back to the PWC, unless you know, so this is the matter after a week.